Welcome to meeting number 24, the House of Commons Standing Committee on Justice and Human Rights. Pursuant to the motion adopted on February 8th, the committee is meeting to resume its study of the government's obligations to victims of crime. We will also go on to go in camera to discuss the travel plan and for this fall and adopt the report on PASEPA subsequent to this first part of the meeting. Today's meeting is taking place in a hybrid format pursuant to the House Order of November 25th, 2021. Members are attending in person in the room and remotely using the Zoom application. The proceedings will be made available via the House of Commons website. For those on Zoom, you have the choice at the bottom of the screen of either floor, English, or French. For those in the room, you can use an earpiece and select the desired channel. Before I introduce the witnesses, just want to let you know that I have two cue cards. When you're down to your last 30 seconds, I will raise them. That gives you a forewarning of 30 seconds. And when you're out of time, I raise the red one. So I ask that you kind of conclude at that time. And it's just in respect of time for everyone else. And I'll do the same for every questions. Now we have, as witnesses, we have Dr. Benjamin Roebuck, a research chair and professor of victimology and public safety, Victimology Research Center, Algonquin College. We also have the Canadian Resource Center for Victims of Crime, Aline Velasanu, if I said that right, Executive Director. Also from the Ottawa Victim Services, Heidi Illingworth, Executive Director. So I will begin. Each witness will have 5 minutes to give their opening statements, and then we'll go for subsequent rounds of questions. If you don't finish your comments in your opening statement, try to flush it out in the questions, or you're more than welcome to submit your statement or briefs to the clerk, and we can add those into the report. So Dr. Benjamin Roebuck, for 5 minutes, please.
Thank you so much. So victims' rights are not an abstract topic. They have real life consequences for victims and survivors of crime. When somebody experiences trauma from violence, they're in one of the most vulnerable moments of their lives, forced to navigate the complexities of a system that can be quick to leave them behind. The crime is deemed to be against the state rather than the person who was hurt, and most of the rights with legally binding power belong to the accused, who's guaranteed the right to a fair trial, to legal counsel, to be provided with information on the case against them. And if these rights aren't respected, a mistrial can be called because we recognize there's been a miscarriage of justice. In fact, sections 7 to 14 in the Canadian Charter of Rights and Freedoms lay out these rights for people accused of criminal offenses, because as a society, we believe in justice, fairness, and due process. When it comes to victims of crime, and this is so important, the legal onus is reversed. Our legislation states that victims can receive information when they request it. And the only recourse prescribed is to file a complaint. In a recent study completed by our research center, we heard from victims and survivors of crime from all across Canada. I've submitted English and French copies of our report to the committee. People shared the real consequences of not being informed, including missing the opportunity to participate in hearings, to be consulted about decisions that affect their lives, and perhaps most importantly, to share concerns about their personal safety, all because they haven't been provided with information because they didn't know to ask, and no one in our current system is responsible or accountable for providing that information. What can make things worse is, according to at the federal level, privacy legislation has been used to justify not informing victims because the federal government believes that this might violate their privacy. And that's a real barrier. Instead, if we draw on a person-centered or victim-centered approach, victims of crime need to be invited into conversations about their privacy and about their safety. According to our former federal ombudsman for victims of crime, who's with us today, information is a gateway right. It's how we access all the other rights that we're afforded. And if we apply the reasonable persons test, we can assume that a reasonable person who's experienced victimization would want to be kept informed on the progress of an investigation, on information about services and compensation, and certainly that they would want to be provided with information about their right to attend a parole hearing or to give information about their personal safety to be taken into consideration. We don't have to make that assumption because survivors across the country are asking for this to change. Section 15 of the Canadian Charter of Rights and Freedoms guarantees the equal protection and benefit of the law, and Section 28 guarantees gender equality. In the case of gender-based violence, I personally don't understand how we can have a system that predominantly provides male perpetrators with information about their rights, legal counsel, and guaranteed access to information in their cases, while predominantly female victims don't have access to the same rights. They'll only be informed if they ask and if they know what to ask, and they might not be consulted about information on their personal safety in the release planning for that offender. Decolonizing justice starts with recognizing the power imbalance that exists when people take what does not belong to them without consent. Strengthening rights and services for victims of crime is nonpartisan, and it's our responsibility in a fair and equal society. Section 24 of the Canadian Charter of Rights and Freedoms guarantees an accused the ability to bring a challenge in court if their rights have not been respected. Currently, victims of crime are not permitted to bring a challenge in court when their rights are not respected, but only to raise a complaint. This makes the Office of the Federal Ombudsman for Victims of Crime crucially important. And while the Office of the Correctional Investigator has a budget of approximately $6 million with 41 full-time equivalent positions, the Victims Ombudsman has a budget of just over $1 million with 10 to 12 FTEs. Even a modest increase of 2 to 4 FTEs would allow the office to recruit additional expertise to develop policy envelopes that can support systemic reviews. There's a lot of work to do. I'm thankful to be invited to the committee today, and I do hope the government will follow through. And thank you for your time.
Thank you, Mr. Roebuck. Dr. Roebuck, now over to Elaine Velasquez of Canadian Resource Centre for Victims of Rights.
Thank you so much. Good afternoon. My name is Aline Blesianu, pronouns she, her, elle, and I'm the Executive Director of the Canadian Resource Centre for Victims of Crime. Every year, more than 2 million Canadians report criminal incidents to the police, almost a quarter of which are violent. The CRCVC comes into contact with thousands of them every single day, every single year, and has done so for almost 29 years. 2020 marked the 5-year anniversary since Bill C-32, Canadian Victims' Bill of Rights, came into force. In 2019, the Department of Justice's review of Canada's criminal justice system acknowledged that victims often feel re-victimized under the current system and argued that major changes are needed to adequately support the rights of victims in Canada. The CRCVC agrees that major changes must be made to the Act as it currently falls short of delivering the rights and protections that it promised. The Act was set out to provide victims of crime with 4 statutory rights: information, participation, protection, and restitution throughout the criminal justice continuum. Since the Act came into effect, the CRCVC has witnessed its shortcomings firsthand and how they have negatively affected victims of crime in Canada. Many of these shortcomings can be attributed to the following issues: sporadic and inconsistent implementation of the Act, limited training for criminal justice officials, and no public education effort to inform citizens of their rights under the Act. The above-mentioned shortcomings and much more were also published in the 2020 Progress Report on the Canadian Victims' Bill of Rights by the Office of the Federal Ombudsman for Victims of Crime. In this report, the office clearly illustrates that the objectives set out in the Act have not been met. The CRCVC agrees with this conclusion made by the OFOVC. When the legislation was first passed in 2015 to create the CVBR, there was also a requirement that Committee of Parliament be designated or established to review the CVBR 5 years after it was enacted. 7 years later, the review has not taken place. Criminal victimization is frightening and confusing. The effects can be debilitating, demoralizing, and leave victims confused, fearful, and frustrated, often exposing them to long-term issues to overcome. Added to these impacts is the burden imposed by the complexity of navigating the criminal justice system. The adversarial justice system relegates victims to roles of observers or witnesses in proceedings between state and accused. CRCVC works daily with victims who are often re-traumatized by a system that should be protecting them. The Canadian criminal justice system fails to adequately and automatically inform them of their rights and the relevant criminal justice procedures. Some of the most common complaints the CRCVC has encountered are learning about hearings and trials after they've taken place, learning about their right to submit a victim statement after the deadline for filing the statement has passed, and being unaware of their right to information about a federally incarcerated offender and unknowingly coming into contact with their offender when they are eventually released back into the community. While the CRCVC assists in a number of ways, a large part of our services are to help individuals navigating the shortcomings of the CVPR. For example, the CRCVC helps registered victims of crime navigate post-trial agencies such as Correctional Service of Canada, the Parole Board of Canada in their search for information and participation in the hearings of their offenders. And it also helps victims who have had their rights violated to file a complaint, as well as support those who have not had their violations addressed correctly. These services are directly related to the shortcomings of the Act, as victims do not have real, tangible remedies available to them when their rights under the Act are violated. Simply put, moving forward, we must hold officials and the system accountable for ensuring that victims' rights are delivered to them in a practical way. As outlined in the OFOVC's progress report, there are a few recommendations to address this lack of accountability. Specifically, introduction of an automatic provision of information about victims' rights and remedies, designating a list of officials who have direct responsibilities to victims of crime within the criminal justice system, and naming the Office of the Federal Ombudsman for Victims of Crime as a single authority with jurisdiction to review complaints by victims of crime in relation to how they were treated by a federal department, agency, or body. In agreement, CRCVC also recommends the following: guaranteeing support services and assistance for victims, collecting national consistent data aligned with rights enumerated in the Act, and assisting victims with collection of court-ordered restitutions for the losses they have suffered. Furthermore, it's important to note that the OFOVC was created as an independent resource for victims of crime in 2011 to ensure that the federal government meets its responsibilities for victims of crime. While the responsibilities of the OFOVC sound promising on paper, it is difficult to follow through with these responsibilities, given that there is no current federal ombudsman for victims of crime. The position has been vacant since the end of September. This is an affront to all victims of crime throughout Canada who rely on the OFOVC as an independent resource. As the committee responsible for reviewing the government's obligation to victims of crime, the Canadian Resource Centre and myself is calling upon you to use your voice to advocate on behalf of victims of crime in Canada who have had their voices stifled. Thank you.
Thank you, Ms. Lasanu. Now we'll go over to Heidi Illingworth of Ottawa Victim Services for 5 minutes.
Thank you. I don't know what happened to my camera. It's not turning on now, but I hope you can hear me. Good afternoon. My name is Heidi Illingworth. I'm the Executive Director of Ottawa Victim Services. OVS is a community-based agency that provides emotional support, practical assistance, referrals, and advocacy to individuals who have been victimized as a result of a crime or tragic circumstance. Merci de m'avoir invité.
Thanks for having me.
The government has clear obligations to victims of crime. The 1985 United Nations Declaration of Basic Principles of Justice for Victims of Crime.
Ms. Illingworth, I'm just going to have to pause. I think there's a rule that your camera has to be on. I'm just getting a message from the clerk. If you can just pause for a second, and we'll try to get technical IT services to resolve this issue.
Someone will be contacting her in the next few minutes.
I've been told we can resume, as interpretation does have Miss Illingworth's text, so they don't need a video to help them translate. But hopefully we'll get this sorted out before questions. So Miss Illingworth, continue, please.
Okay, sorry about that. I don't know what happened. It was working earlier. The federal government has clear obligations to victims of crime. The 1985 United Nations Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power sets out clearly that governments must provide victims with access to justice and fair treatment, enable offenders to make fair restitution, offer victim assistance and support services, and set up financial compensation programs. It is my position that Canada has largely failed to meet or maintain international standards and obligations to victims of crime. Passed in 2015, the Canadian Victims' Bill of Rights is weak legislation. It is symbolic rather than taking real effect. It neither guarantees rights nor services to victims of crime. It was drafted in such a way as to purposely deny enforceable rights to victims of crime. The Act specifically states that none of its provisions can be interpreted as giving any victim standing in court to challenge authorities on whether their rights have been met. When I was ombudsperson, I recommended the Act be amended to provide a legal remedy for its violation. Currently, the Act prevents victims from legally enforcing their rights, either through judicial review of decisions or other administrative mechanisms. Further, the CVBR places the onus on traumatized victims and survivors to know and assert their rights instead of requiring criminal justice officials who have a duty of care to victims to provide information automatically. I believe the Act should be amended to clearly define roles and responsibilities of criminal justice officials towards victims. The Act must set out which officials are meant to inform victims of their rights and when they must do so. It must also require them to document what information is shared, how protections are delivered, etc. So authorities such as the police, Crown prosecutors, and corrections and parole officials must be accountable for providing the rights that are laid out in the Act to information, to protection and support, and they should also have to report publicly on how they do so. Implementation of the CVBR has been a failure in my view. There is a lack of data collected, reported, and recorded at all levels in relation to the rights that are provided in the bill. There has been no effort made to measure the impact of the bill or outcomes for victims. Significant investments are needed to improve the recording of data by all criminal justice institutions. And implementation also requires the development and evaluation of ongoing training for officials working in the criminal justice system at the federal, provincial, and territorial levels, those who come into contact with victims. This has not happened. It is critical that an evaluation take place to examine the content of the training, who's delivering it, how much training individuals receive, and what the impacts are. We must evaluate the effectiveness of the training on criminal justice personnel, especially trauma-informed principles and anti-racist education, so we can deconstruct power and privilege. In my view, the objectives set out in the Act have not been met. And like I said in the progress report, the implementation has been sporadic and inconsistent. Training opportunities for justice officials have been very limited, and there has been no mass public education effort to inform Canadians that they have rights if they become a victim of crime. Thus, the situation of victims of crime has not fundamentally changed since the bill was passed. Victims of crime face a very heavy burden in the Canadian justice system. And I know you know this, but we expect them to report the crime, to provide evidence, to bear witness, to be cross-examined on the stand, to relive their traumas over and over and again, over and over as they tell their truth. And yet we provide them with very little assistance or protection to do so. Unsupported victims are less likely to come forward. And when victims' rights are not when victims are not recognized as rights-bearing individuals in the criminal justice system, the system is less effective. Canadians deserve transparency. They deserve to know whether our justice system is treating victims fairly and supporting them to recover, and if it's respecting their legislated rights or not. Canadians lose trust in the justice system when the rights of persons harmed are systematically overlooked. Thank you.
You're welcome. Thank you, Ms. Illingworth. Now we'll continue to our first round of questions, beginning with Mr. Brock for 6 minutes.
Thank you, Mr. Chair, and I sincerely want to thank all witnesses today. I've listened very carefully. I've done some research on my own prior to your appearance, and you bring collectively such a wonderful perspective on a deeply flawed system, a system that, in my view, was pronounced, or this particular bill, I should say, was pronounced in 2015 with great fanfare as trying to level the playing field for victims across this country. And leaving aside my profound disappointment that the office itself does not have an ombudsperson in place and has not had that vacancy filled since September, the end of September of last year. And now hearing through one of the witnesses that the mandatory review has not taken place within 5 years is deeply concerning to me. As a former prosecutor, I often remarked that there was a lack of balance in our criminal justice system, that the pendulum itself had so shifted in the favor of the accused that the victims themselves often felt left out of the process. And it's incumbent upon all justice participants, including those particularly in the Crown Attorney's Office, to try to include victims in the decision-making. And that's usually the process that I adopted as a prosecutor, was trying to develop that rapport and that trust to make them feel that they're part of the system, to keep them informed throughout the entire process. But the way that I conducted my prosecutions vastly differed with my colleagues, and vastly differs, I might say, with the entire province of Crown Attorneys, at least in Ontario. So can I get some sense from any witness as to what additional steps by way of professional training do you recommend for justice participants to ensure that the victims themselves feel as an equal participant in this process? Anyone?
You want to start, Ben? I can jump in. Certainly, I think that training is very important for Crown officials. In light of the Victims' Bill of Rights, certainly, Mr. Brock, it sounds like you took a very sensitive approach when you were a prosecutor, but we don't always see that, and we know that Crowns are very busy prosecuting many, many cases, and so there's not always the time to sit with victims and explain things and how what to expect, what they can expect as they go through the system. So we absolutely need to see more sensitivity training, more training around the rights that victims have, them being provided information about the supports that they can access when they're called to testify, testimonial aids, that sort of thing, their rights around impact statements and what that looks like when they can prepare one, and the requirements around that, because we know there's a form now and there are restrictions around what can be said. And so victims need all of that information. They need to be guided through that process. And depending on the province or territory, there isn't always victim witness assistance staff to do that with victims. So it's really important that Crown takes time to do that, and that there's training that is, national, federal, that is ensuring, and we have a consistent approach to how we support victims as they're going through the difficult process of giving evidence in court.
Thanks, Miss Illingsworth. I have one further question for you as well. You talked about legal remedies, that the legal remedies perhaps should be better reflected in the Victims' Bill of Rights for clear violations, and there had been violations clearly for the last 7 years. But also keeping in mind the evidence of Dr. Roebuck in terms of the charter rights that are available to all Canadians including victims, do you feel personally that charter violations and the ability to argue charter violations should also form part of the Bill of Rights?
I think that would be very interesting. I think we need to move towards having some sort of system where we can test that. But I think certainly in the progress report that I made when I was ombudsperson, I talked more about starting with maybe having an administrative review of decisions not to prosecute, for example, so that victims could have a higher level of review there. Or if there's a decision made by a federal body, having the ability to seek a federal court review of such a decision, like a parole board decision, that sort of thing. So I think that maybe those sort of mechanisms would be a good area to begin to test, have sort of a test mechanism for victims' rights.
Thank you.
Okay.
Thank you. Can I move on to Dr. Roebuck on that particular question? What sort of path do you envision to empower victims to pursue charter violations? Dr. Roebuck.
Thank you. Yeah, I think when we come into these areas, we actually have a lot of the expertise already to respond across the board because we're already doing it with people who are accused. I think I see the out of time sign. So
sorry about that, Dr. Roebuck. Hopefully we'll be able to extract that out in the next round. The next round goes to Madame Briard for 6 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. I'm not sure if you're able to hear me properly. We're having an electricity breakdown right now, and my headphones are not working on my phone. If I'm told that the interpreters can manage, then I will continue. Yes, it seems that they can. Thank you so much. My question is for Ms. Illington. Thank you for what you've been able to tell us, and thank you for your being involved in this issue, and you're working alongside people who have been victimized, who are victims of crime. I understand that you have called for stricter laws on firearms. Of course, this is an issue of the highest importance to our government. As you know, we recently tabled a bill about firearms, C-21, which I hope will be quickly adopted in the House so that we will be able to continue protecting citizens in my riding of Sherbrooke and across Canada. I would like to hear your opinion on the red flags position that the government is putting forward within C-21. Could you tell us a bit more what you think of that concept? Thank you.
Thank you for the question. I wasn't prepared to respond fully on gun control and red flag measures. I did make recommendations when I was ombudsperson on those issues in support of, a quicker ability for police to remove firearms, for medical folks to be able to intervene to remove firearms when there was concerns. Because my understanding is that the process can be delayed somewhat now. So I think that's all I'll comment for now, but certainly support increasing the ability of officials to remove firearms from persons who may be at risk.
Okay, thank you.
We also know that research shows that restorative justice can be beneficial to victims, to offenders as well, and also improve public safety. Could you tell us how the withdrawal of certain minimum sentences and the redirection for some punishments for crimes could help us in this regard?
Heidi, Elin, and I all recently returned from a conference in Spain with the World Society of Victimology, where a large emphasis was on the application of restorative justice and how it's being applied in different countries around the world. And I think the evidence is very clear that restorative justice provides better options for victims, that they get to participate meaningfully, and often they get more from the process than just the traditional outcomes of the criminal justice system itself. What we see in Canada is this patchwork fabric where government talks about restorative justice but doesn't back it up with funding. And funding is really important. We have an exceptional program in Ottawa that's done severe cases of violence to the minimal, and they struggle from year to year to pay their 2 primary staff. That's very common across the country. I think restorative justice and the evidence is very clear. We need to better provide options within the justice system to participate, and we need to provide funding for those programs, which provide incredible benefits not only to victims, but also to the accused who participate in those processes.
Merci beaucoup.
Thank you very much. In Spain, did you hear of any specific programs? Do you have any specific examples you could share with us?
Yeah, so in countries like Belgium, it's a legislated process for the youth justice system that all cases are automatically referred to restorative justice as the primary mechanism of criminal justice. We heard about applications of restorative principles and responses to armed conflict, but really, I think there's very established work about the need for it being victim-centered. I think what we did hear clearly was that there's ways to meaningfully apply restorative justice in cases that are sensitive, like partner violence and sexual violence, whereas in Canada, sometimes we're hesitant around some of those types of offenses because we talk about power imbalances. And I think it's important to recognize that those power imbalances continue to exist in relationships, regardless of whether there's a safe facilitated process. And so actually, I think we have room to explore the broader application in all types of violence, because if it's done safely with facilitators who can meet with both parties in advance and afterwards and provide that follow-up care, I think a lot of work can be done in that process that creates a much safer society.
Merci beaucoup.
Thank you very much. Do you think that victims are sufficiently aware of their rights within Canada, their rights to protection?
What Heidi said, it's questionable whether victims actually have rights in the Canadian experience, because if they can't follow up with meaningful recourse, if they can't challenge it in the courts, then it's more of a statement of what we'd like to see. So no, I don't think people understand restorative justice sufficiently. I don't think that we advertise it particularly well, and I think we can do better, but we also need to strengthen access to meaningful rights.
Who and when should receive the information and provide the information?
I'll stay with this thread if that's okay. I think just like if something was going to proceed to trial, the police would inform the victim that they've been requested as a witness, that the offender would be informed that they're required to attend. I think just in the same process and the same mechanisms of communication, that option for restorative justice, which should be voluntary between both parties, can be offered at the same point in time.
Thank you. Thank you, Madam Briard, and thank you, Mr. Roebuck. And next we'll have Monsieur Fortin for 6 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. My question is for Ms. Illingworth. Ms. Illingworth, welcome to all 3 witnesses while I'm at it. So good to hear from you. You are all able to answer all the questions we have. That's pretty clear. It's very helpful to have very competent witnesses here before us when we have such deep issues to discuss. That said, Ms. Illingworth, I would like to know, in your view, I understood that you have been an ombudsperson. You have not been holding that position for a couple of months now. So what is the effect of such a long absence of an ombudsperson on the very rights of victims and the management of that program?
Thank you for the question. I do think it is concerning that the position has been vacant for this period of time. It's really an important position to ensure that victims feel that there is someone in the federal system that is there to hear the concerns that they have. So as Aline said, it becomes an issue that stresses victims out further when they feel that they understand that the office has staff, but when the position is vacant, there isn't somebody to actually oversee those complaints that are coming in and perhaps make recommendations or start systemic reviews, right? To look at those issues, those emerging issues that are coming forward. So it's frustrating not only for victims and survivors, but for service providers as well, who are dealing with clients who need to make complaints sometimes. So yeah, we understand these processes take time, and we're hopeful that it's moving forward to having someone appointed soon.
Merci. Est-ce que vous...
Thank you. I understand from what you're telling us, and I understand from what all three of you have testified before us here today, that one of the main failures of the program, maybe the most important one, is the lack of adequate information provided to victims about the rights that they do have. So here's what I'm wondering. Ms. Ellingworth, you were an ombudsperson, and do you think that the ombudsperson would be able to improve the information network available to victims? Is there something that could be carried out by your eventual successor to ensure victims get more information?
I think that's probably tricky given the size of the budget of the office. It's very small budget. There needs to be a massive public education campaign around citizens' rights should they become victims of crime. And I think that is something that one of the federal departments, whether it's justice or public safety, they need to undertake. And perhaps it'll coincide with the review of the Victims' Bill of Rights. But I think that's really important. Citizens simply are not thinking that they're ever going to be affected by violence and crime. And when they are, they just often don't know where to go, who to turn to, that they have rights in the system. So we need a more robust, public education, social media.
Merci, Madame Ellingworth.
Thank you, Ms. Ellingworth. I'm terribly sorry. I don't wish to be impolite, but we don't have much time. I would like to put a question to Mr. Roebuck. Right now, the ombudsperson reports to the Department of Justice, the Minister of Justice, all said and done. Senator Boisvenu once recommended that they report to the Parliament as a whole. I'd like to hear you on that, Dr. Roebuck. Do you think that it would be wise to transfer the responsibility of oversight to that ombudsman to the House?
Thank you. That's a very good question. I think there's benefits to both approaches, but I do think that reporting to Parliament provides a stronger mandate for the office. The intent of an ombudsperson is that it's an independent authority that actually has the right to bring a challenge to the current approach. So there's a power imbalance if that reporting can be stopped at the Minister of Justice, who's approaching issues in a particular way, rather than to the wider body that's representing the interests of Canadians. I think when we look at something as significant as criminal justice, that the input of governance from a wider body is appropriate. And I think, like Heidi said, I think that a move in that direction would also necessitate a stronger portfolio of funding and the capacity of that office, even if it's not substantial increase. I think some increase to bolster that capacity would be an added benefit that would significantly help victims of crime.
Est-ce que le mandat de l'homme...
Is the ombudsperson's mandate in need of revision?
I think similar to the Office of the Correctional Investigator, there need to be some policy leads that can help with the systemic issues. We know that many people who experience violence in Canada never progress to the point where they're a victim with a federally sentenced offender. And so to uncover some of those aspects, looking into racialized disparities, the barriers that Black families experience with gun violence, and this almost reverse onus to prove that their victim wasn't involved in gang violence. There's a lot of these issues that need to be disentangled, and we could do that better with some capacity that's added.
Thank you, Dr. Roebuck, and thank you, Monsieur Fortet.
Merci, Monsieur le Président.
Thank you, Chair.
I'll next go over to Mr. Garrison for 6 minutes.
Thank you very much, Mr. Chair. And I want to thank all three witnesses today, not just for appearing here, but for the work they do each and every day on behalf of victims. I don't think we acknowledge the actual amount of work that's done with the slender resources available in this country. So I think that that's important. I also want to say I've heard three things today I would like to ask about, but I don't think they're actually questions for our witnesses, because all three of them have talked about the need for mandatory information sharing with victims. All three have talked about the need for legal remedies, and all three have talked about the need for adequate resourcing. But I don't think those are actually questions for our three witnesses. They're questions, I guess, first of all, for ourselves as a committee, and secondly, for the government. And I also want to say, I think probably every member of this committee has raised with the government the need to fill the position of the Federal Ombudsman for Victims of Crime in a timely manner, and we're well beyond a timely manner. And so we wait, as victims do, for this job to be filled. So I do have three questions I do want to ask. First, I'll ask Dr. Roebuck as the academic, and I always confess to being a recovering academic. Do we have any idea of the reach of victim services now? In other words, of all the victims that we have in the system, how many are actually getting any kind of services? Is there any way for us to judge the size of that problem?
We do have some measures. Previously, Stats Canada had a survey of victim services, and the provinces that are running provincial victim services have metrics where they're recording and the services are reporting back on the number of people served. I think if we were to compare that with the GSS data, the victimization surveys, we know that the number of people who are accessing services doesn't come close to the number of people experiencing victimization. So there's certainly a gap, and what we see in those pockets is that we need better race-based data because there's discrepancies in which communities benefit more from victim services, and there's work to be done, but we need better information. And we're just starting to see the impact of race-based data to help us address systemic inequality.
And I know I'm not going to try and tie you to a figure, but the magnitude of that gap, how big is that gap? Is it half not receiving services? Is it 3/4? Is it 10%? I know that's an unfair question to an academic, but can you give us an idea of the scope of that gap?
I can say large and complex, of course. I think there's lots of reasons that people don't go through the justice system, and sometimes the supports that we offer for victims of crime are tied to the justice system. So we hear certainly from people who are underserved in terms of, say, something as severe as a murder-suicide. If both the perpetrator and the offender, perpetrator and the victim die, the family members are left without a lot of the services that other people might. So there's such a wide discrepancy, but certainly an area for more focus.
Okay, thank you. For Ms. Belasano, when victims of crime approach the Resource Center, what are the main services or assistance that they're looking for?
So we normally act as kind of a systems navigator for victims of crime in Canada. So a lot of the time folks come to us because they don't necessarily want to report to the police. So they're trying to figure out what rights and what services they can access given those circumstances. And unfortunately, within Canada, things like compensation programs and victim services, they're done provincially. Therefore, they vary vastly from province and territory. So a lot of the time they're kind of left, as Ben mentioned, somewhere in the middle, and they're not sure what to do. Also, because they're not getting informed of their rights if they are reporting to the police. Sometimes they're not told that they can bring someone with them when they're going to the police, or the fact that they're able to do a victim impact statement, or that there is a deadline for that victim impact statement, or that there's a lot of rules that you have to follow when writing that, or even navigating post-trial agencies, because their journey doesn't end when the accused is put away, right? That journey continues, not just a healing journey, but if it's a federally incarcerated offender, it's hearing after hearing after hearing. And we can act as a support person during those hearings, and we can help them write their statements. We can also read it on their behalf, because we know it can take a really big toll on victims.
Okay, and I'd like to ask a more difficult question, Ms. Illingworth, as the former federal ombudsman of victims of crime. The resources available to the office, we all know, are inadequate. But could you give us an idea of the kind of things that the demands the office was not able to meet because of those resource limitations?
Well, I just think that, you're really limited in the number of systemic investigations that you can undertake, emerging issues that you can look at, because the staff, the full-time employees count is so low, as Ben mentioned. You can only undertake so many projects. So, essentially one large report a year, perhaps. And so, there's a limit on translation. There's a limit on communication. So, you really have to decide as the ombudsperson what issue you want to focus on, based on the complaints that you get or issues that are brought forward. And unlike the correctional investigator who can make have you seen the annual reports? They're huge. They focus on many, many, many systemic issues. The Ombuds Office for Victims of Crime is much more limited in the work that can be produced as a result.
And my last question here, I think for anyone or all three of you, is there a recognition in our mental health system of the need for services to victims who've gone through these traumatic processes?
Very briefly.
I can just say, I think there is some sort of recognition most times, but I think there's just not enough resources to go around. So even when victims are trying to apply for compensation, which includes accessing mental health supports, the long wait lists and things like that just act as another barrier for victims, or just the limited amount of sessions that they have available to them. For example, in Ontario, it's about $1,000, which is less than 10 sessions per person.
Yeah,
Thank you.
Very time limited.
Thank you, Mr. Garrison. Next over to Mr. Blake, Mr. Richard, for 5 minutes.
Thank you. I feel a little bit like I've kind of come full circle. Back when this legislation was put in place, I sat on the Public Safety Committee, and we reviewed the bill as it was being put into legislation. And I remember at that time, many people who came before the committee telling us that one of the big challenges was the lack of information that victims had. And there was a belief that this bill would help to address that. It appears as though for whatever the reasons are, that hasn't been the case, or at least not to a large enough degree. And I want to touch on that in a second, because first I want to just go to, it's come up a few times, both in questioning and in your opening remarks, but obviously the position of the commissioner being left vacant. I really see that as a slap in the face to victims. And I want to just ask if all three of you can just, talk to the impacts that has on victims, that position being left vacant. If you can do it as concisely as possible, but just give a sense of what is the impact on victims of that position being left vacant. Whoever wants to go first.
Sure, I can go first. I think just the fact that I have to tell victims that position is vacant when they think that there is someone there is really grueling for me and my team, because a lot of the time when victims are frustrated, we really feel that, right? Because we're working with them frontline. And a lot of victims just feel that it really underlines the fact that victims don't necessarily have a voice within the system in Canada. And I think a lot of the time while they're traumatized, it's really re-victimizing to know that there is a position created, but not enough investment to actually have someone in that position.
Okay. Does anyone have anything they want to add to that?
Yeah, I think right now we're in one of the most complex transformations to criminal justice that we've seen in history. During the COVID-19 pandemic, the transition to virtual service delivery, so much change, which means so many gaps that have been created. So many people whose cases have had added complexities are still needing resolution. So to have the absence during the COVID-19 pandemic with all of those adaptations, which are still ongoing, means that a lot of people are left without help and recourse and do need for sure somebody who's looking into those issues.
So what you're essentially saying is that you couldn't imagine a worse time to be leaving the position vacant.
That's right.
Yes.
Okay. Can we turn to the to what I sort of alluded to at the beginning? The fact that victims don't receive the information they need to be able to properly participate in the process, to be able to make sure that their stories are part of the justice system, to make sure that they're being treated with respect, that they're being treated in the appropriate way, in the way and ensuring that they their impacts are considered as fully as they need to be in the system. You've all kind of mentioned that you feel that that's really preventing victims from that proper participation in the process. Tell me what is it that's actually missing? Why are victims not able to get the information they need, and what can we do to fix it? I don't know who wants to start.
I'll start quickly, Ben, before you go. I just want to say really quickly, I think a huge gap is around police provision of information about rights. We know this bill applies to the criminal justice system, so you have to report the crime to be able to access the rights and participate throughout the justice system. So the first step for me, really critically important, is that all police be required to provide a victim's rights information card to victims. I made that recommendation as ombudsperson. I understand the RCMP is moving forward with that, which would be amazing if that actually happens. But all police services in Canada should be providing a little handout that tells people they have a right to information, to access restorative justice, to protection, etc. The rights outlined in the bill.
Okay, I want to maybe want to come back to that and just ask a follow-up question, but I'll let you mentioned Mr. Roebuck. You I think had some stuff to add to this, so I'll let you go first, and hopefully there'll be time that I can come back for a follow-up on that statement you just made.
I'll keep it really brief. We have a big gap in the transition from provincial to federal victim services, where cases tend not to get passed along. So if somebody doesn't register as a victim in the federal portal, they won't be informed of the parole hearing and their ability to impact an impact statement. So there's a massive gap that happens at that level.
And what do we need to do? I'll follow up on that first. What do we need to do to make sure that people are aware that they need to do that? Then what would be the step that could be taken to make sure that people are aware of that need?
There's a pilot project in BC to help merge some of the data from provincial to federal system. What the problem right now is, we need to shift beyond thinking that it's a privacy violation to proactively connect with people who've been impacted by federal offenses. That's the barrier right now from my perspective.
Okay.
Thank you. Thank you, Mr. Richards, and thank you, Mr. Roebuck. Next, I will go to Mr. Naqvi for 5 minutes.
Thank you. Thank you very much, Chair. And Dr. Roebuck, I will go back to you again. I'll start with you because you talked about data, and that caught my attention. Victim services is a shared responsibility between federal and provincial. So tell us a little bit about your experience in terms of how is that shared responsibility is navigated, and especially in terms of data. What is the state of data across the country among various jurisdictions?
I think often minoritized populations or racialized populations are served by more informal mechanisms of support than the traditional systems. One of my big questions at the federal level would be race-based data for people who are registered in the Victim Services Portal. Are we reaching the wide range of people who've been affected by federal crimes or federally sentenced offenders, or actually is there a bias in who's accessing support? That's a big question. And I think the Ombudsman could help, but we need at the federal victim services level a data strategy that really explores who's getting access to these services, who are excluded, and that we can identify some of these gaps.
do you have a sense through your research what those gaps are at this moment?
Yeah, so for example, in the research that we've done both with victims of crime and with victim service providers, we have two very large surveys of folks across Canada who've either been affected by crime or involved in the victim services sector, and both have predominantly white samples, even through outreach through formal organizations. To reach other people, we need to get into some of those informal support mechanisms. For example, in Ottawa, there's a pastor who's done 7 funerals for Black homicide victims. Because the burden as a Black minister is so large that community connects with him. There's these people who are working so hard who need support, and we need to validate our data to be able to identify these gaps and say, hey, there's work to be done. We need to shift resources into outreach and to connecting with these groups.
Thank you.
Could I just add that we know that certain groups, especially BIPOC citizens, we know many are over-policed, right, overrepresented in the criminal justice system, and then we know they're also underprotected as victims. So as Ben said, we have to start looking at this race-based data, who are victims, who are not accessing services and support, who are not reaching. And a lot of the data that we have, as Ben said, is really showing that we're serving white settlers, right? And we're not serving perhaps many groups who are being really negatively impacted by violence.
So I'll ask you, Ms. Illingworth, you're Executive Director of Ottawa Victim Services, and I'm from Ottawa. What kind of outreach, awareness, or education that Ottawa Victim Services is involved in when it comes to minority communities in the city of Ottawa?
That's something that I'm working on actively right now. We have a brand new project in anti-race, anti-hate outreach officer we've just added to our team to try to reach the communities who are impacted by hate crimes and let them know that we have services and support available to them. So trying to diversify our staff, our board as well, so that we can build relationships with communities, working with racialized folks. So I've been doing a lot of work since I took over as executive director in the fall, but we have a long way to go. Definitely, we know our clients do tend to be newcomers and racialized folks, and we need to make sure that we have culturally safe supports for them, and that they feel safe to come to us and access supports, and that we can accompany them as they journey through the justice system.
One area that I have or a group of people that I've not heard much about in the discussion today is Indigenous peoples of Canada, and ways or what your experience is as to how Indigenous victims are provided services.
Very short answer, please.
A lot happens within cultural programs and within communities, certainly even in urban centers, but there's significant gaps. And I know there's growing attention being placed on calls for an inquiry into missing and murdered Indigenous men who are largely excluded from the previous investigation, but also whose lives and disappearances are worthy of investigation.
Thank you, Dr. Roebuck. Now we'll go for two 2.5-minute rounds, beginning with Monsieur Fortin.
Merci, Monsieur le Président.
Thank you, Mr. Chair. My question will be, a question for Ms. Illingsworth, the former ombudsperson. Could you tell me, compared to the Canadian population as a whole, what victims go through, the advantages and disadvantages, are they the same across Canada? including Quebec, or are there areas in Canada where the experience differs remarkably?
Yes, I would say that there are areas of Canada where your experience will be very different. Certainly, we know the more rural that you live, the more north that you live, there are fewer services available and supports to access. So that can be a challenge when you're reaching out for help. When communities are so small that everyone is known to each other, there's a lot of stigma, can be especially difficult to access service. When family members of perpetrators, for example, are involved with providing service in some communities, we've heard that problem. So yeah, I would say that there's lots of challenges, and especially around financial assistance and compensation. We know that programs are very great.
Thank you, Ms. Illingworth. I have 1 minute left. I would like to put a second and last question to both yourself and to Dr. Roebuck. Would it be smart to come up with a change to the criminal code to ensure that victims be automatically included in any court proceedings in criminal matters? At present, of course, you have the Crown prosecutors, then you've got the accused. Could we not insist that the victim be there as a third party in all instances?
There's countries like Germany that have introduced the option for a victim to be a third party in the criminal justice system, even to have their own legal representation or to act as kind of an affiliate prosecutor. I think there's evaluations that are coming out of some of those approaches. I think it always has to be voluntary. So, you know, we recognize that some victims would want to participate in that role, some would not want to. And so I think that we need to have options and choices for how victims engage with the system.
Merci, Dr. Roebuck. Et Madame Henning.
Thank you, Dr. Roebuck. And Ms. Illingworth?
Time for that to Mr. Garrison for 2.5 minutes.
Thank you very much, Mr. Chair. I want to take my last 2.5 minutes here to talk about coercive and controlling behavior and intimate partner relationships. And I know that Dr. Roebuck has done some research in this area. And I guess in the context of victims, I'm really going to ask about the services available and the difficulties of providing services to victims of intimate partner violence. Maybe I can start with Dr. Roebuck.
I know that Heidi had engaged with some academics on that specific topic, so I might prioritize Heidi for speaking time.
Okay, thanks. Yeah.
Thanks, Ben. We have a significant challenge around coercive and controlling behavior not being part of the criminal code. Emotional and psychological abuse is not recognized. So we know that many victims of intimate partner violence are actually suffering not from physical violence, but this controlling behavior, this sort of invisible cage that they are put in by a partner, completely controlling all aspects of their lives. And so we deal at my center at Ottawa Victim Services, we deal with a lot of survivors experiencing this and not certain how that they can get help. And so a lot of what we offer is safety planning. We sit with them, we talk about staying in the relationship or eventually perhaps choosing to leave the relationship if that's what they decide is best for them. But we certainly have a lack of legal mechanisms. Like we know that the police can't respond when there is non-physical violence occurring or abuse occurring. And so that's a real challenge for the justice system. And when I was ombuds, I certainly was supporting the call for criminalizing this form of abuse in Canada.
Thank you, Ms. Illingworth. Maybe I'll go back to Dr. Roebuck, who was gracious and give him the last 30 seconds on this.
I think we have really good examples. The UK has recent legislation that criminalizes coercive and controlling behavior because it's such a violation of someone's free will and independence. I think we also need to recognize that these behaviors occur across all genders and in any relationship. So it's happening in queer relationships. Predominantly, it's happening with women with male partners, but it also happens with male victims with female partners or same-sex partners. And I think when it comes to services and responses, we need to recognize the broad spectrum.
Thank you. Thank you, Mr. Garrison. Thank you, Dr. Roebuck. That concludes our meeting here today. on Victims' Bill of Rights. We'll now suspend for about 5 to 7 minutes. I will ask everybody to re-log in that's using the Zoom apparatus. They've given the in-camera links. It was emailed to you at 1:10 p.m. By the clerk, so please zoom in the new link, and then we'll resume in about 5 to 7 minutes. Thank you.
you.